Court of the State of Minnesota.
Good morning, please be seated. We have one case for argument this morning, the state of Minnesota versus John Joseph Jorgensen. Let's see, Ms. Plant, you've reserved 10 minutes for rebuttal. You may proceed when you're ready.
May it please the court, counsel. My name is Jennifer Plant, and I'm here today representing the state of Minnesota. Today, I ask you to find that subdivision 1-4 of Minnesota statutes section 609.27 and its cohort 609.275 are not unconstitutional restrictions on speech, and to reverse the Court of Appeals and District Court's findings to the contrary. The state's argument here today is simple. This is a statute that regulates unprotected speech. This is a statute that regulates speech that's targeted at a specific individual to inflict injury by overcoming his free will for personal gain. It is not a statute that regulates all threatening conduct. It is not a statute that regulates all threatening words. It is not even a statute that regulates words that convey unsavory, offensive, or embarrassing information about other people. This is a statute that restricts the actor from using a very specific, limited category of unprotected speech to overcome another person's will and force an intended result.
Counsel, as you were describing the statute, you used the phrase personal gain. Where in the statute does it say it has to be for personal gain?
The statute does not say personal gain with those specific words. It does talk about a benefit that accrues to the actor or the defendant, or a loss that accrues to the victim.
So it might be personal gain or it might not be.
Potentially, yes. And I would say that goes to the heart of counsel's overbreadth argument, but of course the state's position is that A, this is unprotected, so we don't need to get to the overbreadth analysis, but B, even if it is subject to the overbreadth analysis, it is not actually overly broad. But as
do you concede, does the state concede that, so let me just back up one second. The defendant here was charged with attempted coercion.
That's correct.
Is there any argument that because he wasn't charged under .27 that he can't make an argument that .27 is overbroad?
Well, Your Honor, I mean,
is that argument in your brief?
It's not in the Supreme Court brief. I raised that before the Court of Appeals and they disposed of it rather handily. And my assumption was that this court would want to get to the underlying issue, which is really, is this statute overly broad? Because I think we would be facing the same issue over and over again were we to continue to charge out attempt statutes with respect to this type of threat as it's defined under 1-4 and be revisiting this issue again if we did not address the constitutionality of it today. So it would be capable of repetition yet evading review, which I think is likely why it's here before the court today.
And Counsel, can we talk a little bit about the procedural issues that opposing counsel raises, for example, the waiver argument, indicating that they're claiming that the argument has been, that your principal arguments here have been waived?
We can talk about it, Your Honor. I'd be happy to do so. No, the state did not waive its argument as to the fact that this statute is constitutional. That's been the state's position all along, first of all. Secondly, with respect specifically to the case that counsel cited in his brief to underscore his argument about waiver, I went back and I looked at that case. First of all, it's a bit distinguishable because it's a probate case, but the underlying cases for those two, in the Inree Estate of Grote case, actually uses the word theory to mean issue in those cases. So in those cases, the litigant actually had not raised the issue at all in the district court and instead had raised it only once it was on appeal. Here, the issue always has been whether this statute is...
But counsel, over here, Justice Hudson.
Sorry.
I know it's hard to tell.
It's bouncing all over in
But,
here.
Yeah, but if you go back to, you know, basic principles of Theo versus Stitch, you don't get to switch horses in the middle of the stream, even on theories. And so I think your opponent's point is you didn't argue fighting words as one of the categories of unprotected speech and tell your PFR to our court. And it looks like that's true. And so that's why the Court of Appeals doesn't address it at all, because you never raised it. Isn't that the case?
With respect to an argument in the district court now, as far as when the fighting words issue was raised?
I guess that's my question. When did the fighting words, because that's a significant exception, and it seems like here now you're hanging your hat primarily on that exception.
Primarily, although I would argue that there's some overlap with respect to these different categories of speech, which is not something I necessarily fleshed out, because as I'm sure you're aware, there's a relatively limited amount of time in which you have to put together a pretrial appeal on behalf of the state. But irrespective of that, the categories are delineated as far as the case from Shaplinsky, where it enumerates these various categories. And of course, they're pretty finite and exhaustive lists. We're not allowed to create freewheeling new categories. Fighting words was referenced, I believe, in my initial brief with the Court of Appeals, as were threats, as was extortion, and primarily in the Court of Appeals, I did focus on the idea that this was generic extortion. But I do disagree to a certain extent with Your Honor's characterization of the case law with respect to switching horses midstream, because after having gone back and looking at those cases and looking specifically at what it was that counsel was doing in the appellate process versus the district court, they actually were raising new issues versus new sort of theories of the case.
Okay, fair enough, counsel. Let's assume that it's properly raised. One of the things I noticed in your brief is that you seem to be equating threats to fighting words, but not all threats are fighting words. And your opponents cites a number of examples where someone might threaten someone. One is the airline pilot example, and I forget what case that comes from, but someone says to an airline pilot, if you don't disclose to the public and to your employer that you have a chemical dependency problem, I'm going to out you. I don't know if those are fighting words. So help me with that. I think that's a problem for your position. Can you help me with that?
Well, there's a lot of different things going on there, Judge, in your question, so I'll do my best to address them.
Probably true.
So first of all, and I did grab counsel's list of hypotheticals here to address that. So first of all, the word threat is meant to convey an expression of an intention to inflict harm or injury. So first of all, it's questionable with respect to the specific example of a pilot who has a disease or chemical dependency or whatever it is. I think it just says secret illness is what it actually says in counsel's brief. So is it really a threat to, or is it really a message that you're going to inflict harm on someone if you're encouraging him to seek treatment? Is it really an intention to inflict harm on someone when you're encouraging him not to fly a plane and perhaps either jeopardize his own life or the lives of others? I think it's a bit of a stretch to suggest that that's actually an infliction of harm. We want people to get chemical dependency treatment. We don't want pilots to be flying if they're ill.
Where do you get infliction of harm in the statute?
Well, the word threat is defined as an intention to inflict harm. So that's a dictionary definition. It's also that sort of cluster of common law ideas where the word hasn't been explicitly defined in the statute, but has been used over the course of time.
But doesn't the statute define threat in six different ways?
Yes, it doesn't actually.
Why do we have to go to the dictionary?
Well, you have to go to the dictionary because it starts out saying that it prohibits threats, and specifically it prohibits these 6 threats.
It says the following threats, and then it describes what the threats are, and none of them say anything about harm.
Well, actually, if you read it in context with the rest of the statute, it does.
Well, actually, one does say inflict bodily harm, but then one we're dealing with doesn't.
Right, but you have to construe that portion of the statute with the sentencing provisions because we can't read the statute or certain words of it in isolation. And so when you look at any of the sentencing provisions, all of them require that in order for this particular crime to be charged out, there has to either be, back to Justice Lillehog's point, there either has to be a benefit that accrues to the actor or a loss that accrues to the victim.
And you don't think it's a loss to a victim if somebody threatens to expose something that's going to cause you to lose your job? Isn't that a harm to the victim?
That he would lose his job?
Yeah, the airline pilot would lose his job.
Well, I think you're making an assumption about whether he would lose his job just because he has an illness. I think that's a bit of a stretch, actually. It's possible that he might be put in administrative leave or something like that, and you could argue whether or not that's actually a harm. And I would say that that's really what would come down to a jury question rather than what does this statute mean. So let's get back to what this statute means. It's not restricting pure speech. It's not saying you can't tell people that this airline pilot has a disease or a chemical dependency problem. It's not saying you can't tattle to his boss. It's not saying you can't take out a billboard on 94. It's not saying you can't take out a full page ad in the Star Tribune. It's saying you can't threaten him and tell him you're going to get him in trouble unless he gives you what you want.
Okay, well, let's take an obvious hypothetical that was alluded to in the Court of Appeals opinion. It's a Me Too hypothetical.
Sure.
You've got a law professor at a local law school who regularly sexually harasses female students. And one of the female students comes to him and says, here's your choice. Either resign from the law school, or I am going to go to the Star Tribune and the dean, and I'm going to put a billboard on I-94. Is that unlawful coercion?
Well, under the statute as written, could you just start again with the hypothetical? I got caught up in all the different billboards and publications.
They were the methods of communication
Yes.
you were suggesting.
Yes,
But the bottom line is the law student says to the professor, you got a choice, resign, which presumably would cause pecuniary harm,
right,
or I'm going to expose your secret.
right.
And up till now, you've been a secret sexual harasser. It ain't going to be a secret anymore.
Sure.
Is she guilty of unlawful coercion
Well,
under the statute?
I guess that would come back to whether different areas of the statute, is it a secret? I mean, is this something he's studiously he's studiously kept concealed from other people, or is it just something that isn't known yet? Because again, we're talking about a secret, which is the language the statute uses, and it may or may not be
Okay,
a secret.
assume it's a secret.
Okay. So that would be the situation we were talking about earlier with respect to the misdemeanor provision, where maybe there's no pecuniary measure here necessarily.
So it would be a crime.
That's speculative. I think to a certain extent it would be a crime, but just because it's a crime.
Crimes aren't a certain extent. They either are a crime or they're not. Do we have a crime here in this Me Too situation?
From what I'm understanding of the way you're describing it, yes, it would be a misdemeanor under the statute, but that doesn't make the statute unconstitutional, because the question under an overbreadth challenge is whether that one situation, now she could bring an as applied challenge where it charged out, but the question is whether that one situation demonstrates a substantial overbreadth and reaching of substantial amount of protected speech relative to the statute's legitimate sweep, which here is, again, protecting words that are used to overcome someone's free will for the benefit of the actor. There's been a lot of focus here on what about this and what about that. And a statute can't be rendered unconstitutional with that really strong medicine just because we or counsel can come up with a handful at best. I think maybe here there's 10 of hypothetical examples wherein there might be something that we don't feel good about that could be criminalized here.
Counsel, could I ask you about if we do feel that the statute needs to be narrowed, you suggest fighting words. But when I look at what happened here, I don't know if the fighting word exception would even be satisfied here.
Well,
What about this would be likely to cause violence?
in this particular set of facts.
Yes, in this particular
set of facts, we have a father who is a government employee working in law enforcement, whose adult daughter has young minor children with whom she's being threatened and interference with her right to parent these children. She's being threatened via her father, really is the way to say this best. But the threat made to her father was, I'm going to inflict harm on your daughter by reporting her to the nursing board, reporting her to her employer, bringing it to the district court's attention, letting the guardian ad litem know, maybe dropping a dime with child protection. I'm going to interfere with her ability to have custody of her children, earn a living, and potentially even have a place to live when I'm done with her if you don't pay me what I want. Now, this threat is, again, being made to an individual who works for a government agency, and so it could potentially have the effect of causing him shame and disgrace and ridicule if it comes to light that his daughter has been arrested for smoking marijuana or for possessing methamphetamine or whatever it happens to be. But more importantly, we're talking about a man whose child is being threatened and his grandchildren are being threatened. That's really what it came down to in this case. And just because the message came across in a voicemail doesn't mean that it didn't raise this individual's ire to the extent where he might jump in his truck, drive over there and bop this guy in the nose. Those are fighting words. His family was being implicated.
Do we have any cases that you can point to where I'm not aware of any fighting words cases that don't happen face to face?
And there really aren't a lot of fighting word cases in general. It's kind of an archaic term, I would say, at this point, but certainly in the context of modern society with cyberbullying and things like that, we live in a whole new world from the days of Shaplinsky and 1950, I can't remember what it was, or even when this statute was originally drafted in 1967. So there aren't really a lot of fighting words cases, but I think in this instance, when you think about what does fighting word mean, fighting words mean those words that by their very utterance inflict injury. And a threat is an intent.
Well, counsel, it may be that, but the heart of fighting words are words that incite an immediate breach of the peace. And I think that's a little stricter test than what you're articulating. And typically what comes to mind are racial epithets and things like that. I'm not sure this is it. Where's the immediate breach of the peace? That's what the most of the cases talk about.
Right. And again, I haven't found a lot of fighting words cases specifically, but I have yet to see one where it talks about an immediate breach of the peace in isolation without that first clause about words that by their very utterance inflict injury. And that goes back to what fighting words have been defined as further back, which is the fighting words actually.
Well, what about this utterance inflicts injury? Explain that to me again.
In this case?
Yes.
Again, we're here before the court on the facial challenge, so I just want to make it clear that the state's not going to go into the as-applied challenge. But in this case, again, it's the threat to injure someone's child. That's the harm that was at issue here, or the alleged harm. I'm going to get your daughter. I'm going to get her every way I can. I'm going to take away her kids. I'm going to take away her job. I'm going to take your money, and maybe I'll come back for more. That's what those words convey. Now, going back
back to Justice Schudich's question, though, if we disagree with you and find that the statute is unconstitutionally overbroad, and we get to whether we can do some narrowing or severing of the statute, I wonder again. I share her concern about whether or not fighting words can be substituted when the statute doesn't say, as it reads now, says nothing about fighting words. I mean, Hensel talks about that. That was the criticism in Hensel, saying that in that statute, nowhere does the statute mention fighting words or incitement of immediate breach of the peace. Don't you have a Hensel problem here?
Well, Judge, I don't know that you do, but I think we need to remember here today, first of all, that we're reviewing the statute de novo. So you don't need to rely on counsel's argument. You don't need to rely on my argument. You're looking at this statute from scratch. And I'd really encourage the court to think about that.
But I need to consider the precedent of this court, don't I?
I agree, Your Honor. Yes, I didn't mean to imply otherwise, but the court has also said that you can use the narrowing construction of fighting words when they're implied here. And again, the idea of a threat.
And that's what I'm getting at. Where is it implied here when the statute is completely silent about that? As
by virtue of the use of the word threat, the intention to inflict harm, the verbal intention to inflict harm. And with respect to the overbreadth challenge, because I do want to get to that, and we haven't had a lot of time to talk about that yet. But first of all, we need to know how far the statute sweeps, since that's the biggest concern here. And again, my original premise is that this is unprotected speech. And so one of the things we need to look at here is how much speech is this restricting? And I'm going to get to the heart of that. And I want to reiterate, going back just a second, Justice Lillehog, to what you and I were talking about before with the billboards and the advertisements and everything else. This is not restricting pure speech. If you have a message that you want to shout out from the rooftops or put in writing, you can do that. You can expose anyone you want under this statute, and you're not going to be held criminally liable or charged by the state for coercion. You can let everyone know what it is you have to say. You can do it orally. You can do it in writing. We're not prohibiting you from doing that. That leaves open a vast amount of speech with which you can still engage. So that's very important to remember, because this is an exhaustive list, Justice
So counsel, in
Keefe.
this instance, if the billboard had just simply said X smokes pot and there was nothing else accompanying that, that would have been fine?
Assuming it was true, yes. Because let's not forget, the statute also prohibits one from threatening to make defamatory statements. That really hasn't been the focus of either of our arguments, because I don't know that that really has legs.
So your point is you can expose the secret, you just can't accompany with a threat to
Exactly.
expose the secret. So, okay, so you said there are only a handful of cases that would cover protected speech. I consider maybe that a little bit of a challenge. I like to ask hypothetical questions. Let me ask you another one. A school bus driver knows that a student on the bus is a secret smoker and says to the student, hand over the cigarettes so that I can throw them away. If you don't do that, I'm going to tell your parents. And the student loses the cigarettes. Has the bus driver committed the crime of coercion?
I just need to revisit the statute, sorry. I want to make sure I've got this right here. Well, I think that comes back to whether or not there's a benefit accruing to the bus driver or a harm accruing to the child there.
Kid loses the cigarettes. Worth a pack of cigarettes.
Right. Yes, that's coercion. I don't think it's unconstitutional just because the bus driver got the kid to throw away his smokes.
Can't you literally think of, I mean, if you really worked at it, couldn't you come up with hundreds of examples of threats that are done for a good purpose that we want to encourage in society, but that would, read literally, would be barred by this statute?
If I took the time, I could probably come up with hundreds of examples, but I bet you I could come up with thousands of examples of speech that's not restricted by this statute. And I think when you get back to what it was that the legislature intended to do here, because again, if you're going to—
Wait a minute, I want to follow up on what you just said. The test of substantial overbreadth isn't whether there's a lot of unprotected speech generally that you can do. That's not the test, is it?
No, the test is whether or not it prohibits a substantial amount of protected speech relative to its legitimate sweep. And the legitimate sweep of this statute
Right, we don't
here—
start with a universe of total speech and then say, well, it only prohibits a certain amount of unprotected speech. That's not our legal test.
No.
Okay.
No,
Because I
that's
think
not what
you
I was
said that.
implying. No, what I should have said, and maybe I argued it inartfully, Your Honor, is that there are any number of unprotected sentences that this statute, or unprotected speech
Threats.
examples, yes, threats, thank you, that this statute reaches that would not run afoul of the First Amendment relative to those that might be of constitutional concern, in which case, as this court said in Washington Davis, you would still have an as-applied challenge that you could raise.
Can I want to switch to the topic of severance for just a moment. You don't have that much time left. And ask you, the Minnesota County Attorneys Association says, hey, this is all really very simple. Just sever the non-pecuniary part of the sentence. And then you've solved the statute, any constitutional problem. Now, I didn't see in your brief that you argued that, although the Court of Appeals dealt with the MCA's amicus position in its opinion. Are you arguing that?
Well, I argued that in front of the Court of Appeals, and
But I didn't see you arguing it here.
I focused on a slightly different theory of things, but I agree with the amicus that yes, that would be one way to solve it, is to strike that particular portion. I think that another way to strike it, actually, and we hadn't gotten into this, or excuse me, another way to save it if you were going to get into severability, would be to invalidate, we haven't talked a lot about this, but I think that invalidating that portion of the statute or severing that portion of the statute that talks about otherwise to expose any person to disgrace or ridicule actually is where a lot of the hypotheticals tend to land, because that is a rather, it's a rather broad area, I would say, and it also is difficult to really understand what that means. So I think that actually would be ripe for a vagueness challenge. Not that I want to make counsel's argument for him, but as I thought about what would be a realistic narrowing construction or severability position to take, I really thought that was one that made a lot of sense, because if anything, I think there are some problems with that particular phrase, but I don't think that means that if we even get to an overbreadth analysis, that means the statute's unconstitutional.
Counsel, your red light's on.
Thank you.
You have 10 minutes for rebuttal. Mr. Lebo.
May it please the court, counsel. Good morning. My name is David Lebo. I'm from the firm of Godwin Dold, and I appear for respondent John Joseph Jorgenson. Parenthetical 4 of the state's coercion statute is unconstitutional on its face. It is overbroad because it is a content-based restriction on speech that prohibits a great deal of protected expression. And as a result, this court must strike it down. Ironically, it's Shaplinsky that tells us with a pretty good formulation of why the statute cannot survive. Shaplinsky goes through some of the classes of speech that are not protected by the First Amendment. And it states that such, quote, such utterances are no essential part of any exposition of ideas and are of such slight social value as a step to truth that any benefit that may be derived from them is clearly outweighed by the social interest in order and morality, unquote. Many of the examples that have been presented in the briefing, in the foreign state cases, in the district court's order by the court today, show that the speech that is criminalized by this statute is sometimes of enormous social value.
Counsel, can I just ask you, just looking at Washington Davis and the overbreadth analysis that we did in Washington Davis and trying to follow that same framework. I mean, in your brief, you outline, you say the statute could cover routine litigation demands, business communications, political communications, other communications with elected officials. Those are the examples you list in your brief. And do we have any reason to believe that any of that is being chilled? Any of that speech actually being chilled? I mean, I'm seeing a lot of political commercials right now, and maybe lawyers are all of a sudden not making litigation demands because of this statute, but is there any actual reason for us to believe that this statute, which after all is a blackmail statute, is chilling speech, protected speech?
First of all, I think that's the state's burden to disprove rather than to prove, and there may be questions on that, I suppose, too. But I think the answer is yes. As I've dug into this, I have thought about every time I send a letter with a settlement demand, it's something that I've thought about.
And you keep doing it nevertheless, I assume.
Well, yes, because...
Well, doesn't that mean it's not being chilled then?
No, because, well, I'm in sort of a privileged position in being the litigator for this case, but, you know, US v. Stevens is quite clear that we cannot rely on prosecutorial discretion to save a statute.
But we can rely on as-applied challenges. If in fact it starts to be that politicians all of a sudden become afraid of threatening each other with exposure of secrets because of this statute, you know, then there can be as-applied challenges brought.
Well,
and isn't there some redeeming value in criminalizing blackmail?
In criminalizing extortion, quite possibly. And the argument that we are making today is not that that extortion, you know, do this or pay me money, is necessarily protected speech. There is a...
Well, if that's true, then why isn't the amicus position correct that you can fix this with severability, a severability analysis that deletes the non-pecuniary language, and particularly in light of this case, which is clearly pecuniary, there's no doubt about it. Doesn't severability here work?
No, severability does not work because it flies right in the teeth of what the legislature intended. And that matters only so much for severability because, of course, we're severing unconstitutional language. But the language here is very broad, and all the evidence is that this is exactly what the legislature wanted. In one of the briefs, now I can't remember which one, the state had pointed out some of the commentary that went with the criminal code in 1963. And this statute has not been amended substantively for the relevant portions that we're talking about today since then. And the statute, or the legislature says, I think very explicitly, that it wants this to be broad. I'll quote from a small section of that. The proposed section, therefore, has been prepared on the basis that the forceful compulsion by means of a threat of any act or forbearance ought to be recognized as crime, even though the offense of the defendant cannot be measured by monetary standards. Statutes of some states are broad enough to include this approach. Now, First Amendment has developed a little bit since 1963. You look at Times v. Sullivan, which is, I think, a landmark case in First Amendment jurisprudence, came out the following year. And so the legislature may not have seen this as a problem then, but it wanted this statute to be broad. Severing that language, I don't think it solves the problem anyway, but it flies in the face of the legislature's intent.
So why wouldn't it solve the problem?
Because even a threat with $0 worth of harm is still criminalized, because the statute says, at the end of paragraph, or in the middle of subdivision 2, parent 1, it's a misdemeanor, quote, if neither the pecuniary gain received by the violator nor the loss suffered by the person threatened or another as a result of the threat exceeds $300. 0 does not exceed $300. And so you still have a problem even if the loss or gain is 0. And I'm skeptical of the MCA's position, which it doesn't have the standing to raise at this point, but that's neither here nor there. There's always going to be some loss, some gain. It may be small, but this statute, at a $300 cap for the misdemeanor, we're talking about small dollars.
Let me take the flip side. I don't know if it's a flip side, but a little different angle on this question. As I'm reading your brief and all of the hypotheticals that you cite, and I think some of them are frankly problematic, and I think you correctly identify them as problematic. But as I'm thinking about this, I'm having a hard time seeing how the legislature, under your theory of overbreadth analysis, could ever draft a statute that would meet the demands that you are making today to deal with blackmail. Am I right or wrong about that?
You're wrong, Your Honor. The federal laws that cover this kind of topic have been repeatedly challenged and have, I don't think even have merited Supreme Court review. So 18 U.S.C. section 875D prohibits threat to injure the property or reputation of the addressee or of another, or the reputation of a deceased person, threat to accuse the addressee or any other person of a crime, when that's done with the intent to extort. And
well, and that's my question. Has this statute been interpreted? Because all it says is you have to make a threat and then some result happens. Do you have to, does the speaker have to intend the result to happen?
No.
And is there any case law on that?
No, there's very little case law on this statute. All subdivisions, I think.
So should we interpret the statute as requiring intent, problem solved, we all go home?
I don't think so. You look at 609-275, which is the attempt to coerce statute, the actual statute under which Mr. Jorgenson was charged, and it talks about the failing to obtain the intended result. And yet 609-27 does not have that language. And so the MCAA in particular made a big deal about reading this in its full context and subdivision 2 as an element of the offense. But 609-275, it's not an element of the offense, of course, but it's got to be read in its context with the surrounding statutes. 609-275 says the intended result, 609-27 does not. And
So counsel, in that vein, what about the chief's question to opposing counsel that the individual is actually charged under the attempt statute?
609-275 is not a substantive statute. It has no kind of elements of its own we're looking through to 609.27. And so, we are relying, the state is relying for its prosecution of Mr. Jorgensen on the elements of 609.27. And I'm not aware of anything that says that this very relevant element of the offense can't be challenged just because the state's managed to charge under another statute. If that were the case, the state could always charge, some statute that relies on the elements.
So if we added an intent element and it made it an intent to extort, what's the definition of the word extort?
Well, of course, the court can't do that. If we're talking about the legislature, extort, I think, can be defined in, I think we look back to wrongfulness. And wrongfulness is not an unknown subject with some of these statutes. United States v. Jackson talks about reading in a wrongfulness element into the Hobbs Act. And the problem there is that the Hobbs Act talks about, the term extortion means the obtaining of property from another with his consent induced by wrongful use of actual threat and force, violence, or fear, or under color of official right. And so we are saying it has to be the wrongful use. Here, one of the real problems with this statute from a kind of a mens rea point of view, which broadens the scope of the statute, is that the intentions can be absolutely benevolent. And I really like
Not
also,
just benevolent, but positive.
right. And I really like the airline pilot example because that is, there is going to be some harm to the pilot. The pilot is going to lose income. The pilot may lose his or her job, but that is serving the public good. And again, Shaplinsky talks about this speech being, threats being, the fighting words being able to be unprotected because they are not socially beneficial. There is no social benefit from allowing someone to stand 5 feet from somebody else and yell racial epithets or whatever it is. And so here we're talking about, you're exactly right, Your Honor, socially beneficial speech rather than socially harmful speech. And I think many of these examples, you're right, there are a lot of examples, and the harder you think, I suspect the more you're going to come up with. When we are getting child molesters out of homes where they have unlimited access to vulnerable children because we say, get out or I'm going to the police, or get out or I'm going to write a newspaper article, whatever, that is of social benefit.
Counsel, sort of in that
But where is
vein,
that
though.
happening?
I'm sorry, I don't understand.
Where is that happening? I mean, that seems quite speculative to me.
Well,
I mean, it's a really inflammatory hypothetical, but it seems just rank speculation.
well, we can't and we don't expect anyone to go through and prove the private incidents of these things that.
Well, isn't the whole point that we are trying to create a protective bubble around speech? And so we don't have to show the examples. We assume that they happen.
Exactly.
And that's what overbreadth is all about. You don't have to develop a list where it's not affecting people in the real world.
Right. And again,
that's not the test.
And again, that interacts with the chilling effect of this law, and it interacts with the state's burden to prove the constitutionality rather
But
than.
how does that fit within Broderick and Washington Davis?
In what sense, Your Honor?
Well, in Washington Davis, we talked about needing evidence that speech is actually being chilled.
Well, and Washington Davis was a statute, covered a statute in which the social harm from the statute was very obvious, right? Inducing prostitution.
Well, I would argue that preventing blackmail is similarly beneficial to society.
And yet the scope of the Washington Davis statute is such that the cases that we were concerned about were very edge cases.
We're very what?
Edge cases. They were kind of inherently speculative, I guess is what I would say. These were cases where the social value of that speech was probably pretty slight to begin with.
But
And
we don't go there.
I
In
think,
determining whether a statute is constitutionally overbroad, we look at whether the speech that might be chilled is socially valuable? Do we?
Well, it's protected speech. That's the whole point of socially valuable speech.
I guess I don't have a great answer to your question, Your Honor. I think that when we have to be at least cognizant of the idea that, some of this is inherently speculative, I guess the realism of the example.
Yeah.
And the just plausibility of the example. I mean, I think one of the benefits of these examples that are coming in left, right, up, down is that they are so inherently plausible. And when you look at, for example, settlement demands, you're saying in many cases, and I've said this, this is going to be an embarrassing lawsuit for you. You should settle before we file it. And, pay us $10,000 so that it goes away and never gets filed.
Counsel, kind of in that vein, I'm curious what your response would be to Ms. Plant's suggestion that if we got to the point of severance, that the statute could be saved if we just lopped off or otherwise to expose any person to disgrace or ridicule, because she acknowledged that there is some uncertainty, maybe even vagueness there. And that really what we're usually talking about is a threat to expose a secret. What's your response to that?
I think in some ways that makes the problem worse, not better.
Why?
The MCAA relied on the or otherwise disgrace or ridicule, and trying to say that disgrace or ridicule has to be kind of part of the defamatory statement, has to be part of the secret or deformity. So that, of course, creates a whole new problem right there. But I don't think that solves most of these problems, because you're still talking about, a threat to expose any person to disgrace or ridicule, and that might reduce the number of examples that would work here. But it's not zero, and it's not even close. We're still talking about an enormous number of examples. That
So you think there's still it would still include a substantial amount of protected speech?
Absolutely, and I think many of these examples, maybe slightly modified, could still work.
Counsel, what if we severed it even more and publish a defamatory statement? In AJB, we excise certain words so that the male harassment statute would be constitutional.
And this is something the Court of Appeals considered, and I think it's both sort of under-inclusive and overextensive in the severance. Parenthetical 4 is largely concerned with threats to expose true statements. A secret or deformity would presumably have to be true, or a true secret or deformity for that to apply. Expose a person to disgrace or ridicule, maybe, maybe not, but publish a defamatory statement means that you're including written language, I think, but not oral statements.
Well, defamation encompasses oral statements as well.
Well, it's the word publish. And I think publish rather than say disseminate.
Publish includes disseminating oral statements.
I guess that's an interpretive question that we needn't necessarily answer today, and I'll take your Honor's word for it. But the problem is it really leaves the least important, I think, of the three clauses there existing while the other two go away. And at that point, I think it's really becomes a policy question for the legislature to answer rather than for the court to lop off all that language. And the other issue is, I think that would in large part be covered by parenthetical 3 because it would unlawfully injure a trade, business, profession, or calling. That wouldn't quite overlap entirely.
That'd be per se defamation.
Right.
Defamation.
And there is a defamation, and there is a defamation statute that separately criminalizes this. So I think that's it's not a great solution, even though I don't think it would be sort of completely wrong. Let me put it that way. So I want to turn just for a moment to the presumption of constitutionality. The state has hammered on State v. Mackholtz, both at the Court of Appeals and here. And State v. Mackholtz says what the state says it does, but it is not a statute, or excuse me, it's not a holding that is going to save the state from having to meet, to bear the burden of proving that this statute is constitutional. That's a federal rule. It's a rule that comes from the United States Constitution. Mackholtz, I think every indication is that the court made an oopsie, and it's corrected it many times since.
Say that again, we made a what?
An oopsie.
So you're saying it was wrong, Mackholtz was wrong?
Yes. And I think that the court has implicitly recognized that by never, as far as I can tell, repeating that error, holding correctly that the state bears the burden here in many cases since. And again, even if the court hadn't, because it's a United States Supreme Court rule, it's not something that this court has the ability to.
No, I think, and to that point, in Melkert Dinkel, which is a fairly recent case and one of our, major cases in this area, we were very specific that the state bears the burden.
Yes, and so I think it's worth noting, because some of the questions here kind of at least presume, if not an even playing field, not the burden that the state in fact does bear.
Let me follow up on the Chief Justice's question concerning whether people really are being chilled. Is that an element of determining whether a statute sweeps too broadly or not under the First Amendment?
I don't think it's an element, but I think it is I guess I'd say maybe a factor. If
A factor in what?
Well, a factor in considering whether this does sweep too broadly, because we're using examples, and the more plausible the example, the more chilling it's going to be.
Well, I'm also wondering if the question is, are people really being chilled? How do you determine whether they're keeping secrets that they would not otherwise disseminate? I mean, the whole idea of a secret is to have a secret. That's what the leverage is. So I don't know how empirically we could decide or determine whether somebody is keeping a secret and that they would otherwise expose because of the statute or not.
I think that's exactly right. And, even when it comes again I know that in the context of, for example, family law, this happens with some regularities. You're in a family law mediation and, somebody says, well, I know about X, Y, and Z that you did. Because that's not and if you don't settle with me right now on the terms that I like, I'm going to, call the police and report this. That's not the same parenthetical, but, that's discussed in family law trainings. I remember an article in Minnesota Lawyer about that a couple of years ago. These are not totally hypotheticals. These happen, I think, every day in this state. Whereas Chief Justice Gilday's, the Washington Davis example, those were going to be rare examples, I think, just on their face. I think that's my feeling about the Washington.
Well, the question in Washington Davis, as I recall, was whether the statute prohibiting promotion of prostitution would keep the adult film industry from making porn films in the state of Minnesota. I'm certain a profound question, but I think that was the overbreadth that was being alleged.
I think that's right, and yes, and and Washington Davis did hold that was purely speculative, and
But the cases it cites are for that principle that if there's just a few and on a narrowly drawn statute.
Yes.
I mean, I don't think speculative means you have to develop a list of examples where speech has been chilled. That can't be the law, right?
I agree, and the end of that paragraph in Washington Davis.
So we made another oopsie.
No,
No.
it's
I
a
think you
question
meant
of
something else.
It's a question of real and substantial overbreadth. And, if you can come up with one example and it's a maybe this would be covered, maybe not, we'd have to see. I mean, the fact questions that the state keeps, saying, well, this would be a question for the jury. You've got to get prosecuted and you've got to get there to a jury trial for those questions to be answered. And that is obviously chilling. But again, I think the breadth and depth of the examples here, and again, just the facial plausibility of these examples shows that the overbreadth here is real and substantial. That's kind of I think that's where that question gets answered.
So let's go back to the Minnesota County Attorneys Association suggestion that we strike the penalty part of the statute dealing with non-pecuniary loss. You said that may be neither here nor there. Well, we need to decide whether it's here nor there.
And I mean,
Was that argument made by the state? What's the procedural posture as to that argument?
no, and that's why I say it's neither here nor there at that point in the argument, I suppose, is that the amicus doesn't really have the standing to bring new arguments, new theories, especially 2 business days before our brief was due.
Well, the Court of Appeals, though, considered that argument brought by the amicus.
The Court of Appeals considered, I think that was a different theory that was raised, at least.
No, I don't. Well, tell me why you think it was a different theory. How has the MCA's theory changed from the Court of Appeals to here?
And I think that's at least implicitly kind of recognized because the MCAA didn't say, well, we are going to piggyback on the Court of Appeals's holding. But, well, regardless of whether it was raised, I guess, unless Your Honor is very interested in that, the problem is, again, it flies in the teeth of the legislative intent. The legislature very intentionally put this here, and it's very hard, especially to get that disentangled from the any act, any lawful act. If it's any extortionate act, that's a different question than any act, any unlawful act. My time's up, and if the court doesn't have any other questions, I will return to my seat.
Thank you, counsel. Ms. Plant, you have 10 minutes for rebuttal.
Thank you.
Could you just start with, hi.
Thank you.
Could you just start with that last part first about the amicus suggestion that we sever the language in the sentencing provision, and the response was, well, but the first part of subdivision 1 talks about any act, any lawful act. Wouldn't we be doing, at some point, we're reluctant to do surgery. You know, we might excise a little, we might do outpatient excision,
Right.
but we don't do full-on surgery in a
Right.
hospital.
That's right. And hopefully you wouldn't do so with some sort of secret illness either. But again, I think it's important here, and the amicus did a nice job of this in their brief, Justice Chudich, as far as you're talking specifically about causes another against the other's will to do any act or forbear doing a lawful act. And you're talking about that phrase as it works with subdivision 1, or excuse me, paragraph 1 of subdivision 2?
Yes.
Okay. So that, I believe, is where the Court of Appeals erred when it said, well, we can't do this severance. That's correct that it talks about any act, but the act still has to be measurable in some way. It has to occur. And this actually goes back to my argument in my brief about how do we know that the legislature used limiting language. There has to be a measurable injury, either an injury, I should say, or loss to the victim, or a measurable benefit. And when I say measurable, what I mean is not necessarily measurable in a pecuniary sense, because that's what the legislature says. It doesn't have to be one that's measurable by pecuniary measures, but it does have to be identifiable. It has to be tangible to the extent that it's something that we can see objectively and understand. He got fired. We can identify that as a harm. It's not like, oh, theoretically, I suppose you could say it would be like intentional infliction of emotional distress, which we all know is extremely hard to prove, exactly for the fact that it's not measurable almost at all. But there has to be an act that's identifiable on an objective measure. That's what makes this statute distinguishable from AJB, because among the other ways in which it's limited with respect to the harm that we're talking about. It has to be identifiable. It's not subjective harm that the person feels like they were injured, or the actor should have known in that particular moment that making that threat would play on a person's certain vulnerability under the circumstances. That is not what we have here. What we have here is a threat that makes someone do something he does not want to do for the benefit of another person or with the purpose of inflicting a loss. With respect to the intent issue that council was asked about, I'm sorry, I can't remember who raised it, maybe Justice Lillehag. We do have to read the statute as having an element of intent. That's a basic principle of statutory construction. No one has raised the specter that this is a strict liability statute, and I think it would be a stretch to think that that's what this is. So we do have to read into the statute the requirement that the actor intended to make the threat, and we also have to read it in conjunction with 609.275, which says that the actor intended a specific result. He intended that the person engage in a specific act or withhold from engaging in a specific act. So hopefully that addresses some of those things that were raised in council's argument. As far as there being positive benefits to some of these threats, I disagree respectfully, Your Honor, as far as there being positive threats. I think we're actually depriving the marketplace and the exchange of ideas from that free exchange if we're saying, I won't talk if you give me what I want.
Let's take counsel's, what I think the chief called kind of an inflammatory example. It might be. A sister sees that a man is moving in with her sister and 3 young children. And the sister goes to the man and says, I figured out your secret. You have been convicted of child pornography and criminal sexual assault upon children. You're a danger to my sister and her children. Either you move out and get out of state, or I'm going to the authorities. Does that violate the statute?
Does it violate the statute?
Yeah.
I don't know that there's a threat to inflict harm there.
He's got free rent. He's got to move out. He's got to get out of state. I mean, that's harmful to him, is it not?
Well, I think that's a bit speculative about whether or not that's harmful to him, but that's subjective.
He doesn't want to do that. And
Then she needs to call the cops.
There are monetary consequences for him to comply with her demand.
Right. And her option in this case then is to call the police.
Or tell her sister.
Or tell her
suppose.
sister, or call Child Protective Services, or whatever it happens to be. But again, that gets back to whether this statute is narrowly tailored enough to allow it to pass constitutional muster. And the answer is yes, because she still has the opportunity to engage in that speech. She can still spread that message.
I'm not sure you've answered my question. And under the unambiguous words of the statute, doesn't that threat that she just made violate the statute?
If it exposes a secret, yes, that would be coercion. If he moves out, if she causes him to move out.
Well, or she attempts to get him to move out, it's covered by the attempt statute, isn't it?
It would be covered by the attempt statute, yes.
Counsel, I want to go back to the severability discussion, and I'm looking at page it's A69 of the appendix, the Court of Appeals opinion, and Court of Appeals says here that subdivision 1.4 applies broadly to threats to do any act or forbear doing any lawful act, and the state's suggestion, which was the severability discussion that we had earlier, would mean we would have to sever this language and add new language. How do you respond to the Court of Appeals argument that severability doesn't work here?
I apologize, Justice. Where on page 69?
It's A69 of the appendix. See a page number here, the Court of Appeals.
I have A69. I'm just failing to see that particular.
It's top first full paragraph.
The state's first suggestion?
State's first suggestion.
Okay.
It goes on and it says, because subdivision 1.4 applies broadly to threats to do any act or forbear doing a lawful act, the state's suggestion means we would have to sever this language and add new language.
I disagree.
Why?
Well, I was attempting to articulate that earlier, although perhaps I didn't do so successfully, but that act,
And it may be that I didn't hear you, so. Or
I think I was
understand.
inarticulate, Justice, but again, there's a couple things here. One that needs to be read with .275. It has to be the act that the speaker is intending to cause or forbear. I understand that it says any act, but again, we can't take that very small phrase in isolation and separate it from the remainder of 609.27 or from its attendant provision 609.275. So that's my first response to that. And the second response is if you read it with the sentencing provision in subdivision 2, it actually talks about the benefits received or harm sustained, which implies that this is not occurring in a vacuum again. I'm not asking you to do, you're specifying the intended act and you're specifying it in order to get a specific benefit or incur a specific harm. So as far as counsel's suggestion that someone feels compelled to go to an attorney and pay $500. The statute doesn't contemplate, again, this sort of eggshell victim who we have to take under the circumstances where we find him. It doesn't say if he's vulnerable in that moment and feels that he needs to get an attorney, then we can charge the person for causing him to go to an attorney and spend $500. That's not what this says. It has limiting language that allows us to rein in what threats we're criminalizing. And again, as far as the statute's legitimate sweep, Justice Gilday, back to your point, this is conduct that the legislature decided did not have value in the free exchange of ideas in the marketplace. No, that's not the test about whether it has social value, but the value of the pure speech here is not being trammeled upon by this statute. We can still say, this guy's a child molester. The pure speech is not being restricted. It's only the certain type of speech that we're restricting here, which is threats. The idea that we're going to overbear someone's free will. That's why this is injurious language. Because by virtue of the fact that you're saying, I'm threatening you, you're telling someone you're going to overcome them using this idea of moral compulsion, going way back to Justice Holmes, that we're not okay with. And in the early cases of First Amendment jurisprudence within the 20th century and late 19th century, they're talking about these ideas that, yes, the First Amendment is the most fundamental right, but so is the right to be left alone. And this threat is invading the sphere of our right to be left alone. This is information and speech that's targeted to one person, another, not all people, not in a public forum. The whole point is to keep this information out of the public forum. That's what makes this narrowly tailored and gives it a legitimate sweep for a legitimate government interest. And barring further questions, the state thanks you and have a good day.
Thank you, counsel. Thanks to both counsel for the help you provided to the court in this matter. This case is submitted. We'll issue an opinion in due course. We're going to step off the bench briefly and take off our robes, and then we'll come back out and talk to the students for a little bit. Before we do that, though, please, I could just ask the audience to thank the lawyers for coming on the road with us. We really do appreciate it, counsel. Thank you. All right, we're in recess.
Aye.